Welcome back to Liberty Bites on the Think Liberty Network. I'm your host, William Gadsden. You can follow me on Twitter at William_Gadsden, and follow Think Liberty on Facebook, Twitter, or whatever your favorite social media outlet is. You can also follow me on Facebook at William Gadsden Political Commentator. Give us a follow and a like for updates on new episodes and more. We also have a Patreon now, so if you'd like to support our work, check it out at patreon.com/ThinkLibertyPatrons. So for this episode, we're going to continue to delve into the seemingly bottomless pit of tedious, economically oriented Supreme Court cases. This one involves a poultry plant. Yes, chickens. But the economic ramifications of this case are far more far-reaching than any kind of fowl. And I will not apologize for that joke. So let's break this down. The stage is set with the beginning of the Great Depression in 1929. In response to the stock market crash, FDR implemented the New Deal. Now, most of y'all already know how I feel about FDR and the New Deal, so I'll skip over all of that. But one major part of the New Deal, which was in essence a series of major pieces of legislation, was the National Industrial Recovery Act. This piece of legislation gave the president broad powers to unilaterally establish codes to regulate business. These codes included wages, work hours, and work environments. Now, pursuant to this new power, FDR enacted codes regulating the poultry industry, setting a minimum wage, maximum hours, and sanitation requirements for the workers. After these codes were enacted, the ALA Schechter Poultry Corp., based in Brooklyn, New York, was accused of violating several of these codes. Here's the rub, though. Federal regulation under the National Industrial Recovery Act can only be enforced here if it involves interstate commerce, per the Commerce Clause that we've talked about before. So it's up to the federal government to prove that interstate commerce is taking place. The problem that the federal government faces here is that the shop in Brooklyn buys the slaughtered chickens from poultry dealers inside the state of New York, which means that particular transaction is clearly intrastate commerce. But those dealers bring the chickens in from out of state. So the question that the Supreme Court faces in this case is, once again, what the dividing line is between interstate and intrastate commerce. So are the poultry codes and the NIRA in general applicable in this case? Furthermore, and more importantly, does Congress have the ability to delegate its own constitutional responsibilities and powers to the president through legislative action? Now, on the part of Schechter Poultry Corp., the argument is made that not only are these codes a breach of the Commerce Clause and an illegal delegation of power to the president, the delegation of power involved in the NIRA as a whole is dangerous, because there is no policy to govern and restrict the actions of the president under that law. Why does that sound familiar? Anyway, the U.S. government responds by arguing that it is within its right to press under the Commerce Clause, because it isn't about which operations are occurring, it's about how much that business affects prices and businesses outside of the state, which is clearly moving the goalposts here, based on previous applications of the Commerce Clause, but I digress. Furthermore, the government argues that because economic times are so tough, this is the Great Depression, that only Congress can sort it out instead of, the market. So Chief Justice Hughes hands down the majority opinion here. They get straight to the point where the delegation of power is concerned, citing Article 1 of the Constitution, which says, quote, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives," unquote. Furthermore, the Congress is authorized, quote, "to make all laws which shall be necessary and proper for carrying into execution," unquote. That's that necessary and proper clause we talked about. Its general powers. Therefore, the Congress is not permitted to abdicate or transfer the legislative functions that it is responsible for. Concerning clarification of how the Commerce Clause is to be applied, the majority opinion states, quote, "Neither the slaughtering nor the sales by defendants were transactions in interstate commerce. The undisputed facts thus afford no warrant for the argument that the poultry handled by defendants at their slaughterhouse markets was in a current or flow of interstate commerce and was thus subject to congressional regulation. The mere fact that there may be a constant flow of commodities into a state does not mean that the flow continues after the property has arrived and has become commingled with the mass property within the state, and is there held solely for local disposition and use. So far as the poultry here in question is concerned, the flow in interstate commerce had ceased. The poultry had come to a permanent rest within the state." So that's a lot of legal gobbledygook, basically to say that as far as transportation is concerned, that's handled by a different company, a different business. Therefore, even though it is still in the same flow of commerce, this company cannot be held liable under the Commerce Clause, because as far as this company's operations are concerned, that is all within the same state. While the Congress recognized that the effect it had, while the court recognized the effect it had on surrounding commerce was significant, that alone did not justify regulation on the part of the federal government pursuant to the Commerce Clause. Furthermore, the majority opinion stated that if indirect commerce was allowed to be regulated, that, quote, "there would be virtually no limit to federal power," unquote. So this is kind of the running theme of this entire series, right? Every time a court case comes to the Supreme Court, on the part of the federal government, they're always looking to broaden the definitions, to push that envelope a little bit more, and to have the backing of the Supreme Court to do it. They're always looking for further gain of power here. So what they're saying is, the Supreme Court in this case is saying that if we were to interpret the Commerce Clause so liberally to say that indirect commerce also falls under the Commerce Clause and is therefore subject to federal regulation, then you can label anything to be indirect commerce, and therefore there would be virtually no limit to federal power. Finally, the majority opinion also handed down that the federal government did not have the authority to set and enforce labor practices within each individual state. Because if the government is allowed to control wages, then they could control any aspect of business costs. This is one of the few times when the Supreme Court firmly had its eye on the growth of federal power and quickly stamped it out. So there you have it, folks. A win for the market against an overreaching federal government. But this was the last win that the market would have for a while in Congress, the White House, and the Supreme Court. So next time, we're going to go over one of the worst Supreme Court decisions related to the economy that the country has seen. So join me next time as we go over Wickard v. Filburn. Thanks for joining us, and I hope you'll come back next time to become more liberty-centered with us. I'm William Gadsden with Think Liberty.